You asked and I'm answering. So this video is for anyone that has to put together cross-examination questions. There's just massive disclaimers here because I've been doing this for 17 years plus now, and it's taken me this length of time. I am still learning. I'm still finding the perfect way to do cross-examination questions. Everyone's got their own style of doing cross-examination questions, and it takes practice. Practice. And I think for most litigants in persons, they're doing it once, okay, because it's your case, and you will be doing it for either a contested hearing or a final hearing coming up. So you're not doing this thing over and over again like I am. You're doing it once. So I'm hoping that in this video you're going to pick up some tips. I did actually think about putting together like a kind of seminar, an actual seminar on working through cross-examination questions and bundles. I will be doing a separate TikTok video about bundles, but let me know if you're interested in that. Maybe I can make that happen. So anyway, let's get into it. Also, if you're litigant in persons, and like 70% of people are litigants in persons, you will have various ways that the judge will be addressing cross-examination questions. If there are no allegations of abuse, rare, but if there aren't, then you can just put together your cross-examination questions and deliver them as your script. Always script it. You will, magic's in the prep, sing it with me. So you'll also, if there are allegations of abuse, you may be having a QLR. I know some of you in your comments have said that you guys are having a QLR. They vary, by the way. Some are great, some are not so great. I'll always err on the side of caution and we'll still do the cross-examination questions anyway for the QLR. I'm giving the QLR the flexibility to put his or her own take on it. There we are. And sometimes the questions, if there's no QLR, because hello budget, the judge will want those questions to be sent to the judge, and the judge asks the questions kind of on your behalf. So here are just some tips. So first of all, the first thing you're going to need is the bundle. Now I'll do a separate video about the bundle, but the bundle is the Bible, because that is where all the documents are put together. That's where you're going to find, the court is going to find. So get to know the bundle like the back of your hand. If you haven't got a bundle, do your own bundle. Make it Practice Direction 27A compliant. And yes, I will be doing another video about the bundle. But first things you need are a bundle. Once you've got the bundle and you kind of know your way around the bundle, and look, this is just the way that I work. This is the way I've perfected and worked for over the last 17 plus years. So at this point, I get an A4 sheet of paper. This is so Blue Peter. If you know, you know. I get a sheet of paper and I will look out and lift out the themes/issues. Now the themes are going to be quite standard, because if it's a child case, then you're looking at welfare checklist, and you are going to, or if it's a financial case following divorces, you're going to be looking at section 25 factors of the Matrimonial Causes Act. So first of all, know your list. This is not a list, by the way, of proving that the ex is lying. You are in the wrong arena if that is the case. You're there to show why you want what you want. Now, whether you're in child proceedings, you're there to show what you want. And you do that via the welfare checklist, or if it's in finances, you're going to do that via section 25 of the Matrimonial Causes Act, for example. Then there are the issues between you. So I'll always, if in a bundle, I'll always tend to go to the CAFCAS report or the local authority report, because those are the issues often that the court are going to deal with. So that's what we work with. And then I'll often go to parent statements, because sometimes parent statements can be voluminous, and you don't always, straight away anyway, you don't always get the issues that the court are going to be dealing with. So that's my first thing. And then I get a sheet of paper for each person that we need questions for. So there's always going to be a sheet of paper for the other parent. Then there's always going to be a sheet of paper for the professional or the author of any report. Now that might be CAFCAS, local authority, NIAS, and you're writing questions for them as well. On each sheet of paper, I will be listing out the themes/issues. Now, just to break that down a bit more, the themes are always going to be either welfare checklisty, or they're going to be section 25. And then there's going to be issues that are applicable to the case. Again, massive caveat, I'm not here to talk about whether or not the ex has lied or not. We're not trying to throw shade on somebody's character here. We're there to be very focused and to the point, because if you're there talking about how your ex is lying and how your ex is a terrible person, I mean, don't get me wrong, there may be issues of domestic abuse, but you know, there's a line here, and having that, being that organized and having that process keeps you focused as well. So then when I get onto a sheet of paper, I will lift out the themes and the issues that are between the parties, what's agreed, what's not agreed. Then it comes to the actual questioning itself. So by the time, and by the way, that prep time actually takes me most of the time. Give you an example. So like if I've got a day's trial, I'll typically take a day for a day. That's how I kind of work. So if it's a 2-day trial, typically I'll be taking 2 days to prepare and put together this. So this isn't just about going straight in and asking the questions. There's a process behind it. Once I've done that process and I'm at the point of actually writing the questions, so this is just the last bit, the writing of the questions is the last bit. Some pro tips here. So most questions are semi-rhetorical. You never ask a question you don't know the answer to. Let's be clear as to what you're trying to get out of the witness on the stand. And by the way, the door swings both ways, because the advice I'm giving to you about how to approach cross-examination questions is exactly the same as the other side. They'll be doing the same as what I'm doing. So you never ask a question you don't know the answer to, because you're not actually there to get the information from the witness. You're there to make a point to the judge. This can feel quite repetitious, because you're saying the same things on a statement, you're saying the same things to the CAFCAS officer, or you're saying the same things to the court in your submissions, and you're going to be pretty much saying the same things when you're cross-examining. Now, like I said, if the judge is doing that for you, they'll tend to lift out what's relevant and what's not, because you guys are not experts, okay? And when you're putting this together, this can feel really daunting. Like I said, it's taken me 17 years and I'm still learning, and I've been doing this for a long time. So semi-rhetorical, you don't ask a question you don't know the answer to. You want to keep the questions quite closed as well. So they're not open questions, they're going to be quite closed questions. Often questions that are yes, no, I agree. And being semi-rhetorical, I mean, you know your ex. So but there is a line here, because whilst it's semi-rhetorical, whilst they're quite closed questions, you don't want to make an arse of yourself. You know, there's no point in going into a kind of faux legalese. I don't know. I used to say Rumpole of the Bailey, but I mean, I'm just that old. And if you know, you know. Actually, Rumpole of the Bailey was way before my time. But Suits, if people recognise Suits or any kind of legalese docudrama, people tend to relate to. But you're not there trying to be some faux legal. You're not the barrister here, okay? You're just simply trying to ask the question so that you make your point to the court that you want them to kind of join the dots to your way of thinking, okay? So, and I say don't be an arse about it, because it can feel, especially when there's litigant in person asking the questions, it can feel very pokey, provocative, angry, and listen, say it as it is. You're just making the point for making the point's sake. So, and it's not often focused. It is often angry. And another thing that I tend to find litigants in person, if they're not prepared, is they sort of ask a question, then it's kind of a statement about what they reckon, and then the question rambles on so much that the witness and the court are sort of saying, what's your question? And what's the point? What's your point? So be really clear. The questions, I have them in various sections. So say, for example, children's wishes and feelings, okay? I will have that as a particular section, and as I work my way down the questions, they often follow a path, and the end question is always kind of more a punchy question that kind of ties up what you've been saying in that particular section. There is no way I'm going to get to answer how to put cross-examination questions in a quick TikTok video, but I am thinking of doing a seminar, so let me know down below. But I hope these tips have just kind of helped you at least put some organisation into preparing cross-examination questions. Check you later.